Welcome to our explainer. Today, we're diving into a really fascinating Supreme Court case. It's got everything: a family inheritance, a surprise will that turns up years later, and a legal battle that all hinges on a mysterious fire. This is the story of Maloto versus the Court of Appeals.
Okay, so here's how we're going to break this down. First, we'll look at the family's initial agreement, what everyone thought was the final word. Then, we get to the big twist, the discovery of a document that changes everything. After that, we'll dig into the central legal mystery, reveal what the Supreme Court decided, and finally unpack the huge legal principle this case teaches us about protecting a person's last wishes.
All right, let's set the stage. Our story kicks off with the death of Adriana Maloto and what looks like a really simple, straightforward settlement of her estate, or so everyone thought.
So, back in October 1963, Adriana Maloto passed away. Her heirs were pretty sure she died intestate. That's the legal term for when there's no will. So, they did the logical thing. They all agreed to just split her estate into 4 equal shares. By March of '64, the court had given it the official stamp of approval. Case closed, right? Well, not even close.
For 3 whole years, everything was quiet. That family agreement stood as the final word. But then, a discovery in an old, dusty law office cabinet changed absolutely everything and threw the whole family right back into a legal fight.
That's right. 3 years after the estate was supposedly settled, a lawyer was just going through some old files and stumbled upon a document that would completely reignite this entire family dispute.
And what was in that file? It was Adriana Maloto's last will and testament, written all the way back in 1940. Now, this wasn't just some old piece of paper. It laid out a totally different plan for her property.
And this right here, this is the heart of the whole conflict. On one hand, you've got the simple 4-way split everyone agreed to. But on the other hand, this 1940 will tells a completely different story. It heavily favored 2 of the heirs, Aldina and Constancio, and even brought in new beneficiaries like local charities. Just like that, the equal share agreement was suddenly on shaky ground. So, as you can imagine, this discovery kicks off a brand new legal battle. Aldina and Constancio argue, hey, this will is valid and we need to follow it. But the other heirs, Panfilo and Felino, they come back with a bombshell claim. Adriana actually destroyed that will years ago, meaning she wanted it gone.
And that became the single most important question for the courts to answer. Was this 1940 will still legally valid, or had Adriana intentionally revoked it by having it destroyed?
Now, you can't just casually cancel a will. The law is super specific about how it's done. Article 830 of the Civil Code lays out the only ways. Panfilo and Felino, the opposition, they hung their entire case on that third method, revocation by physically destroying it.
This brings us to a really key legal concept, animus revocandi. It's a fancy Latin term that just means the intention to revoke. The court is crystal clear on this. You absolutely must intend to cancel a will. But, and this is the most important part, intention all by itself is not enough. It has to be paired with a physical action.
So that intention to revoke has to be connected to a real physical act. And listen to this, if someone else does the destroying for you, the rules get even stricter. It absolutely has to be done in the presence of the person who wrote the will and under their express direction. So let's see if the evidence actually met this incredibly high legal bar. The whole argument for revocation really came down to the testimony of 2 of Adriana's house staff, both of whom were illiterate. They said Adriana had them burn some papers, but when they were questioned, their story just fell apart. The first witness, Guadalupe, only thought it was the will because she claimed Adriana told her so. The court said that was inconclusive. And the second witness's story? Even weaker. It was what lawyers call double hearsay. He only heard about it from Guadalupe. It was basically just a rumor. And here it is, the final nail in the coffin for their argument, straight from the court's decision. Even if you assume for a second that the document they burned was the will, the act itself didn't happen in Adriana's presence. Both witnesses said they were alone in the kitchen when it happened. That flat out fails one of the law's most basic requirements.
So now, let's get to the final word from the Supreme Court. Let's see how this all comes together in a major decision, not just for the Maloto family, but for Philippine law.
Now, the opposition tried one last thing. They argued that the case was already settled back in '64 using a legal principle called res judicata, which basically means a matter that's already been judged can't be tried again. But the Supreme Court didn't buy it. The court explained that the first case, back in 1964, was an intestate proceeding.
That means it was based on the idea that there was no will. This new case was a probate proceeding, which is specifically about proving a will is valid. They're two completely different things, so the first case couldn't block the second one.
So the Supreme Court's ruling, its ratio decidendi, or the reason for the decision, was crystal clear. The will was not revoked. The opposition simply failed to prove two critical things. First, that the paper they burned was actually the will, and second, that the burning followed the strict rules of the law, that it happened in Adriana's presence and because she explicitly told them to do it.
And so, the final disposition was to reverse the lower court's decision. The Supreme Court ordered that Adriana Maloto's last will and testament from 1940 be allowed and put into effect, completely changing who inherited what.
So, what's the big lesson here? Why does a family dispute from decades ago still matter to us today? Well, it all comes down to the incredibly high standard the law sets to protect a person's final wishes.
This quote from the decision really gets to the heart of the doctrine here. The Supreme Court is saying that courts have to be extremely careful. If you start throwing out people's written wills based on weak or dubious evidence, you risk undermining the entire system that lets people decide what happens to their property when they're gone.
In the end, the Maloto case is a powerful defense of a person's final say. The law makes it tough to revoke a will on purpose. It's not to be difficult. It's to build a kind of firewall, one that protects a person's last formal testament, their final voice, from being silenced by doubt or flimsy evidence. It's a reminder that in the eyes of the law, there are very few things that carry more weight than your last written word. Thanks for joining us for this explainer.